quite figure that out.
She was hoping somebody else would come down. 3+ hours.
Yeah.
And ride that guy.
Right. Yep. Exactly.
You should
Yeah.
see Tiffany.
Yeah, I thought about coming up.
You should see Tiffany's weather. Yeah. I can't believe all that. Everybody talks a little different. And it has. I don't like it. I
Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. Let me begin by saying Chief Justice Christensen has been attending a Council of Chief Justices, and like the rest of us, hasn't figured out how to be two places at once. But I will assure you that she will be viewing the oral arguments, and participating fully in this morning's cases and this afternoon's cases. So we've got two cases submitted with oral argument and a third with non-oral. So Hayes versus Christian Retirement Homes is now submitted without oral argument, and we'll hear oral argument in our first case. Looks like counsel are ready, and you're splitting your time. And so that's up to you as when you pass the baton. Mr. Cox.
May I proceed? Thank you. May it please the court and counsel. This appeal asks whether 11 90,000-gallon above-ground fuel storage tanks are taxable as real property. And these welded steel pressure tanks have been at the subject site since 1977. They were there for nearly 40 years before Growmark purchased the property in 2016. And they sit on concrete saddle foundations. The fuel is delivered to the site and it's stored in these tanks. There's no blending, mixing, or other processing that's done on the site. The sole purpose of these tanks are for storage. The Chickasaw County assessor assessed the value of these storage tanks at about $2.2 million. On appeal, PAB and the district court held that the tanks were exempt equipment. And those rulings, we believe, conflict with the statute, conflicts with this court's precedent, and with 5 decades of Department of Revenue directives.
About the record, is there anything in the record about whether those tanks were constructed on site or whether they were brought there back in 1977?
I don't know that there's anything in the record that says that. I'm not sure that that's determinative either.
Looking at a rule that gives examples of tangible personal property as that becomes realty after installation, and one of those examples is this is Iowa Administrative Code 701-21911, storage tanks constructed on the site. So that's why I'm asking.
That code section was not a part of this case. I don't have it in front of me, so I can't speak to that, but I can say that in general, storage tanks that are less than 16 feet in diameter are typically brought to the site, and storage tanks that are larger than 16 feet in diameter are usually constructed on site. That's just purely because they're too large to transport otherwise. But
Enormous tanks going down Interstate 80. What are the dimensions of these tanks?
I wish I knew. I can't tell you that.
So that they are movable and in fact are from time to time moved from one location to another?
At the PAB level, Growmark argued that they would move the tanks with them when, if they would ever change locations. But that doesn't really apply in our case, in our opinion, because we think these fall under subsection 1C of the statute, and removability isn't relevant to that analysis. And the legislature uses the words attached or not attached, right? Whether attached or not to a foundation. So removability isn't even applicable under 1C. We believe that the starting point for this analysis is the statute. That's section 427A.1, and it's titled Property Taxed as Real Property. And under subsection 1C, it taxes building structures or improvements that are placed upon a foundation. And under subsection 1D, it taxes building structures, equipment, machinery, or improvements that are attached to the building structures or improvements under 1C. And the parties in this case agree, and I believe it's undisputed, that the tanks are placed upon a foundation in this case, and the tanks are not attached to the foundation or to any other building structure or improvement. And so any question about removability, any question about attachment doesn't apply in our case.
Suppose that it's an improvement as opposed to equipment, because equipment is not mentioned in subparagraph C, is that right?
Improvement is not in subparagraph C. Our argument is that these fall under a definition of improvement. Now, it's not defined in the statute. Neither improvement nor equipment is defined in the statute. But if you look at the Department of Revenue's longstanding directives on the assessments of storage tanks, they specifically find that storage tanks fall under improvements.
It seems like that those directives really focus more on the functionality of the item, whether it's equipment or improvement. And under our state line case, we were looking more at functionality because we were defining whether or not something was machinery under subparagraph E. Where in the statute in either C or D is functionality part of the definition of either improvement or equipment?
The statute doesn't specifically address functionality. You're correct, that would be the state line case, which we say is instructive. That was the case, as you know, it looked at certain storage bins or processing bins. It found that the storage bins were taxable and the processing bins were not. That was the functionality, there was a distinction there.
On the definition of machinery and manufacturing both in the rules and in the statute?
In that case, it was dealing with, I believe it was 427A.1 subsection 1E. But we think that it's still applicable in our case. The discussion in there about bins being either for storage or for processing, there's not a large difference between storage bins and storage tanks. Both of them, they shelter products, they contain products, they store them, whereas processing bins or processing tanks, they process, they mix, blend.
That functionality distinction with respect to the difference between improvement or equipment, how would you make that distinction? How do you determine whether something under that definition is an improvement or an equipment?
If it's a tank that primarily processes, some tanks, it could be that some tanks do both storage and processing, but I think you have
To machinery, doesn't it? That goes to the definition of machinery, not equipment or improvement, doesn't it?
I think processing is just talking about, the use of the tank, right? But I think it can apply to the tanks in our case as well. I think the distinction between processing and storage is also applicable in our case. I think it's not limited to, one type of industry or the other.
And the place that you're getting this distinction about processing is more from the Department of Revenue's manuals and those kind of things. Is there a place in the statute or a rule that makes that distinction, or that would apply processing to the definition of equipment?
Any rule, a formal rule that makes that distinction or applies it in that way. But the Department of Revenue has been handling it this way for decades. Section 421.17 describes all of the duties and authority that the department has, and I won't go through all of those, but in general, the legislature has given the department the authority to oversee the entire assessment process. And part of that is rulemaking, part of that is issuing guidance and memorandums. In this case, we have the Iowa Real Property Appraisal Manual that's issued by the department, and assessors are required to follow that by law, and it gives pricing for tanks. And so it tells assessors how to value tanks.
Appraisal manuals or any of the other department information that you're relying on, are those available to the public, first of all? And do they go through any kind of a similar rulemaking process to be developed?
The appraisal manual is online on the Iowa Department of Revenue website. Anybody can see that. The other memorandums, directives, I'm not sure if they're online or not. But I think that
Should we give the Department of Revenue's manuals and guidelines?
you should defer to the manuals and the guidelines. In state line, there's a discussion about the Department of Revenue, a deference to give to the department, and you said that the department was charged with making rules, but also that they were charged with carrying out the intent of the statute. And I think all of the guidelines or the authorities and the powers that have been bestowed upon the department show that they control or they oversee the entire assessment process. And so I think a reading that would say only formal rules are given deference, I think that's too narrow. In state line, you said that you recognize that the authority goes beyond mere rulemaking and includes the separate but related authority to interpret and carry out the intent.
So if you read Renda, Renda says, you know, under 17A, we give deference to a legal interpretation that's done by an agency to which the legislature has delegated interpretive authority. A grant of rulemaking authority that authorized the agency to interpret the statute is such a delegation of authority. Renda does not say the interpretation has to be in the form of a rule, and often, in fact, as we've applied Renda, it hasn't been. So I think it's two separate issues. I don't necessarily agree with some of the discussion below on that. Does that make sense?
And I also wanted to touch on the City of Marion case. In that case, you examined whether the department had authority to interpret a statute, and you had to determine if the department correctly interpreted the terms athletic sport to include swimming. And you found that the term athletic sport wasn't defined in the statute, and the department had been given authority to create rules necessary for carrying out the statute. And you concluded that because the department had to interpret those terms in order to carry out its duties, they were clearly vested with the power to interpret the term. And so you gave deference to the department in that case. I feel like our case is similar to that, where improvement and equipment are not defined by the statute, but the department is giving authority to carry out the statute. And so they necessarily have to interpret the terms equipment and improvement in order to carry out their duties under the statute.
Let me ask you about another interpretive principle. I think both parties mentioned sort of our cases in which we've said either, you know, tax statutes are going to be construed narrowly in favor of the taxpayer, or exemptions are going to be construed narrowly. And we've talked before about how these conflict and how some authorities have said that we should just abandon those concepts and instead just read tax statutes according to their fair meaning, like we would any other statute. And that could include, if there'd been a delegation of authority, some deference there. But my question is, what do you think about abandoning those sort of traditional ideas?
There's certainly conflicting language out there. Of course, we've argued that, you know, you construe it strictly in this case because exemptions in some cases are construed strictly. Yeah, I think you should look at the statute and the plain language of the statute, but I also think that if the statute's not entirely clear, you look at what the Department of Revenue has said, because they're the ones that have interpreted those terms.
Limit on that? I mean, I understand maybe formal bulletins, but is it sort of every word that descends from the department is a binding interpretation that we should follow? Or or are there no limits?
I don't know if there are limits per se. I can tell you that the department for about 50 years has been handling it this way. So that's some sort of persuasive evidence that it's consistent in the way that they've been handling things. And I mean, assessors have been assessing these tanks for years. This isn't something new that we're trying to establish. This is existing.
Could reflect whether or not these particular tanks have always been treated as improvements or as equipment. Was this a new assessment, or has it always been that way and they were just now challenging it?
Anything new. It had been being assessed this way for years.
Just now as challenging it.
Now, we feel that, PAB in the district court went even further than the McDermott case because they've concluded that these tanks fall completely outside the statute. And we don't feel that result finds any support in McDermott or the statute. It would leave a lot of property that's not taxable. And I don't think that's what the legislature meant when they referred to improvements being placed on foundations attached or not attached.
McDermott case wrong.
Number one, it's wrong on the facts. In that case, the Court of Appeals was relying on the district court finding that the tanks were attached to piping, and the Court of Appeals didn't explicitly find or consider whether the tanks were attached in terms of like a fastening device. Because they said if they're attached to piping, then the ordinarily removable language of subsection 3 applies. In our case, we're arguing under section 1C, which attachment doesn't matter and removability doesn't matter. So it's just a different set of facts. Also, McDermott didn't consider this court's ruling in state line that distinguished between storage bins and processing bins.
Back up for rebuttal if you wish. We'll now hear from Mr. Weisner.
May it please the court, counsel. My name is Brad Hopkins. I'm representing the Property Assessment Appeal Board here today. I promised Growmark that I'm going to give them 10 minutes, so I'm going to try to stick to that promise. First of all, from our perspective, this is not an exemption case. This is an initial determination of whether the property is taxable or not. And to your question, we're not of the view that this is the case where we should change pronouncements about interpretations of statutory law. It's not been briefed by these parties here. And if you actually look at some of the case law that we've cited in PAB's order, particularly I believe it's the Tennessee Court of Appeals case, they seem to apply a similar framework of analysis for tax statutes. The way the parties have framed this case, it's really a question about whether the property is equipment or improvements. Now, I don't think the court should get lost in that dichotomy entirely because at the end of the day, these tanks are only taxable if they're improvements under the statutory scheme. Obviously, the McDermott propane case sort of touches on this issue directly. PAB relied on that case. It believes it's the best authority the parties have yet offered on the matter, and so PAB believes it was correct to rely upon that. I want to talk about the use of the state line decision here. Obviously, PAB was a party to that case. It involved a different statutory provision, machinery used in manufacturing establishments, which this court said in the Griffin Pipe case is actually a narrower class of property. The provisions we're dealing with under 427A in this matter have a broader application to property that is not used in the manufacturing context at all. So we have a concern about just applying that state line test here without sort of recognizing that particular difference. And despite the Board of Review's focus on this issue of storage, there is a clear authority that movability of property is a factor of consideration. It was a consideration for the Court of Appeals in Wendling Quarries. And if you look at the General Oils case out of Tennessee and the Stem Brothers case out of New Jersey, each of those cases involved storage tanks of similar size that were movable, and the Board of Review has conceded here that these tanks are movable.
Haven't been moved in about 50 years.
It seemed to matter to the Wendling Quarries Court, and it didn't seem to matter to the General Oils or the Stem Brothers Court either.
Ask the same question. Does the record indicate whether they were installed on site or not?
Does. I think that is a question. If you look at some of the Minnesota and Pennsylvania cases that exist, though.
At this regulation I cited, storage tanks constructed on the site are examples of tangible personal property that becomes realty after installation. That's an actual regulation from DOR, right? So it wouldn't
Familiar with that?
be controlling.
It's certainly in line with the out-of-state cases where the tanks were constructed on site and those tanks were considered to be real property. So I think just focusing the issue of storage kind of misses the point that movability, if nothing else, is a factor to consider.
What kind of deference we should give to the Department of Revenue?
As to those questions before, obviously, these are not promulgated rules, so PAB had a problem with that under the plain language of the statute, and we're doing this obviously without the Department of Revenue being involved. So that is sort of an issue, but nonetheless, under the RENRA framework, you'd have to ask the question whether these are sufficiently specialized terms to require deference. As to some of the particular documents themselves, the 1985 memorandum that's in the record.
Appraisal manuals, I know you want to be quick.
Appraisal manual, it's a valuation tool primarily, and considering the fact that courts often disagree with the valuations that come out of that manual, it's hard to believe that the manual itself would require much deference under this particular issue.
Terms, there's really two, Renda says there's two reasons why you might have to give deference to an agency's, or why you would have to give deference to an agency interpretation. One is if the agency's been given interpretive authority, which the DOR has, hasn't it? And then the second is if it's a term of art that's specially within the competence of the agency. And so we don't need to get to that second issue, do we?
You've got to maybe consider the fact that I checked yesterday, just on Westlaw, did a search for, I believe it was equipment, and I found 1,000 results in the Iowa code, so it's hard to say.
Particular kind, and then there's been interpretations by the DOR as just concerning specifically storage tanks, right?
Yes, I mean, I have running out of time here, but as it pertains to like the valuation guide that's in the record as well, that was specific to whether it's real estate in the context of manufacturing plants. The memorandum doesn't even entertain the idea that a tank might be equipment. So there's various reasons, but I'm out of time. Thank you so much.
Thank you, Your Honors. May it please the Court. Jenna Wheeler on behalf of the intervener in this matter, Growmark. This appeal does in fact turn on a single question. I think we all agree with that, whether these above-ground fuel tanks are equipment or whether they are improvements under Iowa Code 427A1. To reverse the Property Assessment and Appeal Board's holding on the Board of Review's motion for summary judgment, this court would need to reject McDermott and hold that the above-ground fuel tanks are not properly categorized as equipment, and rather they should be categorized as improvements. And we don't think that would be correct.
Unpublished Court of Appeals doesn't bind us at all, not even precedential, right? So we're looking at it fresh, right? So looking at it fresh, what's your best argument for why we're talking about equipment here?
I think that the framework provided in McDermott is guided by the case in Wendling Quarries, which the Board of Review also agrees was properly decided. And that framework really looks to whether something is ordinarily removed. And we're not talking about ordinarily removed under subsection A13 and that analysis that McDermott really goes through. We're talking about removability in general. And so the Court of Appeals, while unpublished decisions in both Wendling and in McDermott, they do look to removability and the fact that if something is more typically moved from a property and not affixed to the property and less permanent, it is more properly classified as equipment rather than improvements. And I know that the Board of Review is taking this position that, you know, these are akin to storage bins, looking at the State Line decision. But in State Line, if you look back to the briefing, they actually refer to those silos or grain bins as building 1, building 2, building 3. And I don't think that anyone's disputing that buildings are typically improvements. So the only way State Line was even reaching an exception, the only way they could get one because subsection A1C does not discuss attachment, is by looking at that subsection E machinery used in manufacturing exception.
Saddles matter here?
It's undisputed, nobody disagrees that the concrete saddles are able to be assessed. Those are the permanent fixtures attached to the ground that would not be moved if the owner relocated.
Other than holding these storage tanks or supporting the storage tanks?
They are placed there for the equipment to sit on top of, and the equipment can then be, the equipment here being the fuel tanks, could easily be picked up and removed in one piece.
Whether these particular tanks have been moved since they were placed there?
It does not, but the record is undisputed that if Growmark were to leave this property, they would take these tanks with them. The record has an affidavit from Growmark. It also contains a quote on what it would cost to move these, and it is 15% of the cost of what it would be to purchase new. So Growmark would, in fact, take these tanks with them if they moved to a new location, and these are...
With respect to the taxing history of this property, has it been taxed as real property in the past?
It does not discuss that. However, Growmark acquired this property in 2022, I believe, and that is when Growmark brought up the taxability of these tanks with the assessor. And, you know, there was some discussion by the Board of Review about the history of taxation on these, and the Board of Review, in support of their motion for summary judgment, filed an affidavit of the assessor saying, you know, these tanks have always been assessed because they are buildings that serve as warehouses, and this affidavit goes as far to say as it doesn't matter the size of these tanks, they're always improvements, and so size doesn't matter. However, the very same assessor did remove all tanks under 30,000 gallons in Chickasaw County. So those positions don't necessarily line up.
That Growmark entered into to purchase the property in the record, do we know if it was treated as real property as part of acquiring the property?
The declaration of value really does not have any weight on how something is taxed. And the Board of Review did bring that up. The declaration of value does not indicate that these items are personal property. However, put it the other way, had Growmark have indicated in a declaration of value $1.9 million of personal property for these tanks, I do not believe the assessor would have felt themselves to be bound by that. We believe that the Property Assessment Appeal Board properly applied the structure of taxable categories laid out in 427A1C and 427A1D. They looked at both. They looked at the most persuasive case law before it, which was McDermott, identical facts to the case before us today, and properly determined that these tanks are more properly assessed or categorized as equipment rather than improvements. They would be ordinarily removed. That's undisputed in this record. they can be easily removed from the property without destroying the land under it. They're sitting on top of improvements, which are these foundations, and could be picked up in one piece and transported to a new property, and in fact would be if Growmark left.
Growmark acquired the property, right?
Acquired the property with the tanks.
And again, the record doesn't show whether they were installed on site or.
They do not. These tanks are 90,000 gallons, and tanks of 90,000 gallons are able to be removed in one piece, placed onto a semi and moved. So they do not need to be taken apart in order to be moved.
Practical concern, and I guess I'd like you to address it, is I think you would agree that these tanks have been treated as real property for a fairly long period of time, at least from the Department of Revenue's perspective. Maybe it's been 40 years that it's been done that way. And then we have an unpublished Court of Appeals decision in 2022, and now this becomes a live issue. And it seems to me that if this is a problem, that the legislature might be better situated to address it rather than upsetting 40 years of kind of established practice and procedure. So can you address that concern for me?
That is in the process. I think that given that we have Wendling, also an unpublished decision, granted not fuel tanks, Wendling there is talking about truck scales, but that is the framework that then McDermott used to also decide that these fuel tanks are more properly equipment. I think the legislature hasn't spoken on it. I don't think that means that they won't, and I think it's actually in the process. And I do think that proposed legislation at this point would be in our favor, that these tanks would not be taxed.
Department of Revenue had issued a rule, or if they issued a rule tomorrow, that follows kind of their appraisal guidelines and what they've been doing for the last 50 years, would that kind of settle the case? Would we then defer to what they said?
I don't think it would settle the case. I think we still have very persuasive precedent. Also, I think it is telling that the Department of Revenue has not spoken on this. The materials and really the opinion documents that the Board of Review relies on are extremely outdated, and the Department of Revenue.
Fair to say they're outdated if they've been using them consistently for the last 50 years?
I don't think it would be fair to say that they've been using them consistently either. I think that there is outdated information that assessors have not followed within those documents, and I believe we noted this in our briefing as well, such as the opinion documents cited by the Board of Review talk about how items used in processing are taxed, or are not taxed, and that has not been the case law for quite some time.
You the question that Justice May asked earlier, is it time to abandon our practice of referring to tax exemptions as strictly construed and just go with fair meaning? And if we did that, would it affect your position at all?
Really, because Mr. Hopkins with PAB properly discussed this, this is not an exemption case. This is whether something can be excluded as an exception from taxation, and that distinction does matter here. An exemption is construed against the taxpayer, right? But here we have an exclusion and whether something should be taxed in the first place. So I don't think that that would change the outcome here today.
Thank you. Mr. Cox?
Thank you. I wanted to address one question that was asked earlier about, is there anything in the record that shows the assessment history of this property? And there actually is. The property record card for this property was an exhibit marked in the PAB case. And so it would show the history of at least several years, the history of how this property has been assessed as taxable real estate.
In the record that that there are several of these cases that are kind of pending. Is there anything in the record that identifies how the Department of Revenue or any of the other counties have been assessing these similar, at least this size of tanks within specific to the fuel tanks?
anything specific to this size. I can tell you that some counties have put their cases on hold pending the outcome of this appeal. And so how those come out may be determined on how this case turns out. But some counties have taken their storage tanks off of the assessment rolls after McDermott, and I've talked to some of them. It's not because they necessarily agree with McDermott, but some of those tanks are so small it's not worth the fight, because there's hundreds of these appeals, maybe more than hundreds, and it's not worth the fight on these smaller tanks to take it to an appeal. I want to talk about sorry.
Follow up on that, does the size make a difference? Is it your position that all storage tanks are, all liquid type or fuel type storage tanks are improvements regardless of the size and the movability of them?
If you have a large enough crane, any tank can be moved, right? Anything can be moved, but I think we have to focus on subsection 1C that says improvements placed upon foundations, whether attached or not, and so whether they're movable.
Of improvement, which is not defined by the legislature, though. I think that's kind of the key.
So I'll talk about this movability. Iowa law requires assessors to assess property based on present use, and the tanks here are integral to the property's identity as a distribution terminal. And if these tanks are removed, the property can no longer function as a distribution terminal. And so the placement of the tanks is not incidental, it actually defines the use of the property. Now, by contrast, in a case like Wendling Quarries, that had to do with truck scales. If the truck scales were removed, then the property could still function as a quarry. There are many quarries that don't have truck scales. Instead, the product's loaded onto the truck and transported to a third-party truck scale. In our case, like I said, it's different. If the tanks are removed, it can't function as a fuel terminal. And Wendling Quarries, if the scale was removed, it still could function that way. In terms of removal as well, or movability, I think part of their argument is about movable tanks, and it seems that framing may be directed more towards fabricated off-site or easily relocated tanks. Our tanks are 90,000-gallon tanks, and they've been there since 1977. And if tanks are equipment simply because they're theoretically movable, then are all tanks equipment? What about 10 million-gallon tanks that are on site and constructed on concrete foundation? I think if the court concludes that storage tanks are real estate, as State Line and the Department of Revenue have strongly suggested, then they're taxable under subsection 1C, and then once sub C applies, movability is irrelevant.
The State Line case pretty well, because I think I wrote that one, if memory serves me right. And those were like silos. I mean, those were not tanks. It was different. Doesn't that matter somewhat?
The statute that we're relying on for improvement, the size doesn't make a difference, right? It says if they're placed upon a foundation, whether they're attached or not.
State Line referred to them as silo buildings. So weren't we focused on building and we were really trying to decide whether or not they were machinery, but to the extent that they weren't machinery, it was that they were buildings, not that they were an improvement.
Right, they were silo buildings, but the ones that you found that were taxable, they warehoused product, they stored product, just like the storage tanks in our case. They simply warehouse them. The tanks are really no different than a building. They have the same function.
Original questions earlier when you're up here is where in the statute or in a definition does the difference between improvement and equipment determine or turn on their functionality?
That's not in the statute. That's in the interpretations by the Department of Revenue, and then we believe State Line. Thank you.
Chickasaw County Board of Review versus Property Assessment Appeal Board and Growmark is now submitted, and we'll stay up here while the next set of lawyers takes your place. We'll now hear oral argument in the matter of the estate of Herman Carl Stille, deceased, Mayo Clinic-Rochester Appellant versus Floyd County Medical Center Appellee. Mr. Maassen?
May it please the court, counsel. This case arises out of FCMC's inability to include radiation therapy in its proposed cancer treatment center, which the district court correctly found was a condition of its gift. The district court, however, pardon me, then went on to excuse that failure based upon the case of In re Beaver. That was error for two reasons. First, In re Beaver does not apply to charitable restricted gifts. That case did not concern a charitable gift, and its principles have never been applied in Iowa or anywhere else to a charitable restricted gift. Those situations.
Language or rationale of Beaver that would prevent it from being applied to a charitable gift?
Itself, but I take it as instructive that no case in history, quite frankly, has been cited by either party implying that impossibility doctrine to a charitable restricted gift. And
Or a case called Estate of Nugan, not cited by the parties or either side's brief, but it preceded Beaver, but it was a woman who left $10,000 to her city to set up a public library, clearly a charitable gift. And she imposed some restrictions on that in her will about who was going to serve on the library board that actually were illegal. So the district court said, well, gift fails. Our court said, no, it doesn't. We applied effectively the impossibility doctrine. So I think we've got some precedent here. Is there any, for doing this for a charitable gift, is there any other reason we should not apply Beaver to charitable gifts?
well, neither party decided that case. I'm not familiar with it, but there are several reasons why the whole principle of Beaver should not be applied to charitable restricted gifts, and why I submit that neither party found a case that uses it for that purpose. The impossibility doctrine of Beaver differs materially from the doctrine of C. Prey, and I just want to bring up two main respects. The first is that C. Prey, as a requirement for its application, requires that there be a general charitable intent on the part of the donor. That is, if the donor has a specific charitable intent, C. Prey cannot apply and no modification is permitted. The other way that Beaver differs materially from the doctrine of C. Prey is in the remedy. So Beaver either enforces or excuses a condition on a gift, whereas C. Prey, which has developed over the years specifically to deal with charitable gifts, its remedy is to modify the purpose of the gift consistent with the donor's general charitable intent. These can make a very big difference. So when it comes to applying Beaver in the case of where a donor had specific charitable intent, Beaver could be used because it doesn't ask the question of what sort of intent the donor had. That could be used to excuse a condition in a place where a donor, in fact, had specific charitable intent. And then on the other front, on the remedy front, C. Prey has developed over the years to have both the flexibility to be able to modify a charitable purpose where something about a gift is impossible, but still adhering to the general charitable intent that the testator or giftor had. That can make a tremendous difference. Take this case, for instance. Mayo Clinic's gift is for Alzheimer's disease research. That, I think, would be characterized as a general charitable purpose. In re Beaver, because that doctrine does not ask what the general charitable intent of the donor was, it's a binary remedy. You either excuse the condition or you enforce it. Let's just say that Mayo Clinic, their entire Alzheimer's department, left the institution, went to Johns Hopkins or someplace. Beaver would look at that and say, well, now it's impossible to fulfill the purpose of your gift. Do we excuse it or do we enforce it? And unless there was specific evidence that the testator had anticipated the problem, you could excuse that condition and functionally make it an unrestricted gift.
case that see pray may be the right remedy in a lot of charitable adjudication cases, but have we ever said it's the exclusive remedy? And does our see pray statute in Iowa say it's the exclusive remedy for cases like this?
Any case holding that it is the exclusive remedy, but I take as instructive that there are no reported cases, and I've not read the one that you cited, Justice Waterman. But I take as
Found it.
it sounds like you do have a very fine law clerk. But I take as instructive that in the hundreds, and quite frankly, see pray goes back to Roman times, as I understand it, hundreds, thousands of years. There's not a single case in the country that says that impossibility is an appropriate doctrine to apply to restricted charitable gifts. And I also take it as instructive that when the Iowa legislature had the opportunity to speak on the question, the court at 633A 5102 adopted see pray. In the first subsection of the see pray statute in Iowa, it starts with the presumption that restrictions on charitable gifts are enforced, but it will not fail provided that the rest of the statute is met.
Issue of kind of standing, and I guess I'm a little bit troubled because it seems like the clearest part of the residuary clause is the part that the money only goes to Mayo if Floyd County Hospital is not an independent healthcare or an independent status. And I believe that it still is of independent status, correct?
So far as we're aware, it is still of independent status, but that is not the only condition under which that Mayo Clinic takes the gift. There is a second gift over. The trial court did not reach that question, but I think the record is abundantly clear that when Mr. Stille drafted his will with Attorney Kennedy's assistance, he intended to leave in a prior gift over, which had been in the 2011 will, and he had expressed to Attorney Kennedy, I want you to add another gift over because I don't want FCMC to be taken over by a major healthcare organization. The district court made a finding both that the will is ambiguous in that respect, that is whether there's a gift over, and then also made the factual finding that Mr. Stille specifically intended that gift over.
Reconcile that with our, as I understand our cases anyway, that we would just look at the text of the document as opposed to the attorney's testimony about what the testator intended.
Yes, thank you, Justice McDonald. So there are, in fact, 3 doctrines that would have, that we argued before the trial court that would result in the gift over being included as part of the will. First is the ambiguity of the will. Then there's also the implied gift doctrine, which is well established under Iowa law, including the Porter case that we cited below.
Part. I mean, if you're reading the residuary clause, just on its face, what is ambiguous about it? It seems like the ambiguity is created by the evidence extrinsic to the will, not by the text of the will itself.
Too, that this question was not addressed by the district court. The court never reached that question because the court found that the excuse doctrine of Beaver applied. But again, I think any of these 3 doctrines would result in the gift going to.
Decide whether the gift over succeeds to Mayo.
That's a question, if ever, for another time.
A lot of your argument seems to, for both the Beaver argument and see pray, you're relying on this gift over provision. But if we were to analyze that and determine that the gift over to Mayo fails because Floyd County Hospital is still independent, doesn't that undermine a big part of your argument?
I suppose it would, Justice Waterman, but I still think that, again, under the findings that the trial court made, which have not been appealed here, and that is both that the will is ambiguous, and I will come back to your question, Justice McDonald, about why it's ambiguous, but I think as of this point in time, clearly we have a path to the gift and therefore standing. And Justice McDonald, it's ambiguous because of the cases that say that where there are two potential interpretations of a passage in a will, or where the intent is doubtful or uncertain, the court can resort to parole evidence of what the testator wanted.
Yes, I mean, I don't disagree with the proposition. I guess it's its application here. If the Floyd County Memorial Hospital loses its independent status and becomes part of a major healthcare corporation, I give, devise, and bequeath all the rest, da, 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 da. That seems very clear to me what that means. What is the ambiguity that you see in that text?
That is not the ambiguity. The ambiguity is in the testator's intent to have included the other gift over in the event that this cancer center, that is the cancer center that Mr. Stille specified in the first part of Article 5th, could not be built. He plainly intended to gift over, as the district court made a factual finding that that was the case.
I guess I don't want to sidetrack you from your main argument if this wasn't raised, but it seems like our rule is if the text is ambiguous, you look at extrinsic evidence. It seems like you're saying you look at the extrinsic evidence to create ambiguity in what is otherwise completely unambiguous.
Yeah, I think the problem with that construction, however, is that then Article 5th doesn't say where the money goes. It's not specified. I would also point out that Article 5th itself does not even say what property is to be bequeathed.
Excuse me, where does it go if both gifts fail? So, is that wholly irrational for us to consider that that could be the testator's will in this situation?
Irrational, I think it's what is provided for under the law, although I don't think that happens in this case, given the strength of the evidence that Mr. Stille intended to gift over. Contemporaneous notes from the drafting attorney from the meeting at which they drafted this will and it was executed said he's got two conditions. And if they're both don't obtain, one of them being a cancer center, then the money goes to Mayo Clinic.
But Floyd County Hospital can do a cancer center with 5 out of the 6 must-have bells and whistles, just can't do radiation. Is that something we can't excuse under Beaver or CPRE?
It under CPRE because given the definiteness of the detail and what he wanted in the cancer center, that pretty clearly is specific charitable intent. And then also the gift over also precludes the application of CPRE. I think it also precludes excusing that gift under Beaver. Here, the definiteness of the words that Mr. Stille used, both starting with the Cancer Center award could only be made if the funds available are sufficient, and followed that immediately with the things that must be included. He used must twice. Pretty unmistakably, that is, it's a condition and cannot be excused. I would also point out that, and something that I think is another legal difference that the court could speak on, and I think the courts and practitioners would appreciate, and that is that we assert, as stated at page 696 of Beaver, that if the testator specifically anticipated the potential failure of the gift and nonetheless made the conditions mandatory, you don't go any further in the analysis to ask what the testator would have intended. And it's pretty clearly, at 696 of Beaver, it says the gift must fail. And here, Mr. Stille pretty clearly anticipated that this gift might fail for lack of funds by using the words, if the funds are sufficient.
Possible to read the 6 criteria the treatment center must contain as kind of objectives that the Floyd County Medical Center has to work toward, as long as it's working toward establishing a cancer center. I mean, there's no timing requirement in here, and I understand now that it would be impossible to have the radiation treatment because of our certificate of need statute, but it doesn't mean it couldn't happen at some point, and they could keep working toward it in the future. Is it possible to read it that way?
I don't think it is. I think they have to make a baseline showing that they can meet the terms of the gift as a condition of receiving the gift. Otherwise, $10 million goes out to the institution, they spend it, and then the conditions of the will are not satisfied. Again, I take the use of the word must as pretty strong guidance that that is a mandatory condition. Also, the use of if the funds are sufficient. The Beaver case says that where that strong language is used, that's a strong indication that that's a mandatory condition. The other thing, Justice McDonald, that I'd like to point out is this gift it fails because radiation therapy is impossible for two reasons, not one. It's not only that the CON process makes this impossible, it's also impossible for lack of funds. The court so found, it was admitted in testimony.
Go against your argument, though, is it the fact that it's impossible because of the statutory requirement? It doesn't really matter whether or not the funds were available. It would have failed. It was impossible anyway, and that's not something that the testator necessarily would have contemplated.
The question, and I think the will itself unavoidably says that Mr. Stille did anticipate that the funds might not be sufficient, and that might be a grounds for failure. In the part where it says, if the funds are sufficient, I make this bequest for a cancer center. Mr. Stille anticipated that this might happen, and he nonetheless went on to indicate that the conditions and the elements that he wanted in the cancer center were mandatory. And the district court really just missed this, did not even address the second grounds for impossibility. And I think if a testator says, I want a cancer center, but if it can't be like this, then I want it to fail because I've put in these other conditions, but anticipated it might fail for lack of money. If it fails for three other reasons, I don't think that excuses the failure that the testator did in fact anticipate. And that's, I think, a material difference in our positions. So the other thing I wanted to focus on is, in addition,
Clock's confusing because but you're past your 15 minutes. But again, we'll have you back up. You bet. Attorney Lindberg?
May it please the court and counsel. The district court properly applied the impossibility doctrine in this case and ordered the residual assets of the estate to be payable to Floyd County Medical Center to operate a cancer center. Now, I want to start with the questions raised by Justice McDonald regarding the language of the will and what really is the controlling position here. It has been Floyd County Medical Center's position through the entirety of this case that the will on its face is ambiguous. You need not, and case law is abundantly clear as well as to when and how extrinsic evidence can be used. And Mayo essentially skipped the step ahead. You can only introduce it when it's ambiguous. And even in that case, you can't use extrinsic evidence to modify or change the terms of the will. And that exactly is what they are trying to do here, is to modify and add an existing condition. I want to talk a little bit further on some of the discussion regarding that Mr. Maassen was just making about these criteria in the will. Under Mr. Maassen's reading, had Floyd County Medical Center expended funds simply to, quote, put an area for administering radiation, it could have satisfied the will. Then there would be a room unused that is not able to provide any treatment for the facility here. That certainly is not what Mr. Stille could have intended, nor what this court could require here in that circumstance. And the district court appropriately used extrinsic evidence in determining the intent under the impossibility doctrine. So certainly there are two separate discussions of extrinsic evidence in this case, and we would posit that the use of the extrinsic evidence when looking at the intent under the facts of Beaver is appropriate. And under those facts, it is abundantly clear that Floyd County Medical Center is the primary charitable target for Mr. Stille. In Iowa cases,
Clear that Mr. Stille and his lawyer were unaware that the radiation treatment was impossible.
it's clear they testified they didn't know. And certainly Mayo's position has been, we have to prove that they knew it was impossible. But certainly Beaver, the other cases, And in fact, the underlying restatements actually show the obvious. We assume when a testator is writing a will that they're not writing something to be impossible. And
On that, first of all, as I was reading the record, I read it that the attorney didn't know whether or not the decedent knew. Is that true?
I too. So there was no testimony, Your Honor, introduced specifically as to whether or not Mr. Stille did or did not know that this was impossible. No one could testify to that fact, certainly.
And as I read the will provision, it seems like to imply that he or somebody knew that there might be an impossibility, right? That if counsel was saying if the funds are sufficient, but what it actually says, I think, is if the funds available make such establishment possible, right? So, I mean, there is the sort of contemplated impossibility built right into that.
Contemplated that perhaps the funds would not be sufficient, but here, the funds are sufficient. It is undisputed that the cost of the money available in the will would be sufficient to provide a fulsome cancer center as detailed by our hospital administrator. But also, as to Justice Oxley's question, if the funds in the estate were $1 billion, we are still faced with the impossibility that is not apparent on the face of the will in the statutory and regulatory requirements of the CON. And so I think you need to treat them as separate impossibilities because they are separate for different reasons.
Fail.
Does the Mayo gift fail?
We agree with Mayo that gift to your client fails. What happens to the money? Does it go to Mayo Clinic, or does that gift fail because your hospital is still independent?
The position our hospital is independent and thus the further exercise is not necessary. The district court ultimately did not conclude what would happen if the money, if the impossibility on the cancer center was found.
Overcome this gift over argument that seems to be a factor in CPRE, but also in the impossibility doctrine. Don't we need to determine whether the gift to Mayos would succeed or fail?
To look at the gift over to really apply Beaver under the impossibility, because the factors in Beaver, we're still going to look at the motives of the testator here, right? And so the motives here are when you can, again, as I mentioned, introduce extrinsic evidence to look at the meaning of what he said. You know, the attorney notes cited by Mr. Maassen clearly say Floyd County was the primary charitable target, and then it must remain independent as what's underlined. It's clear from the evidence that the independence factor was very important to Mr. Stille. When he told the former hospital administrator that Floyd County was in his will, he told him if he remained independent, that the independence was in both factors. You know, Mr. Stille was a farmer in rural Iowa. He had no medical background. He would have no reason to have understood that there were statutory requirements here. The last gift before his death was to Floyd County Medical Center. Over the course of his life, he gave more money to Floyd County Medical Center. So as the trial court found here, Mr. Stille had really stopped donating to Mayo Clinic, and all these hospitals really support the idea that Floyd County was his target. And ultimately, when you're looking at any interpretation of a will case, you are looking and guided by the pole star here, which is the testator's intent. That is where this always comes back to. And in the Iowa charitable gift, I mean, it is fundamental case law there too, that you are to interpret charitable gifts liberally so as to ensure that the gifts can be upheld because they were intended to have a charitable purpose.
The CPRE doctrine to uphold the gift to Floyd County Hospital?
I'd argue that this is a restrictive gift, and thus Beaver would apply from an impossibility standard. I think there's no reason why Beaver cannot be applied here. I don't think it would change longstanding principles of the CPRE doctrine here. A lot of those cases are post-modifications after many years of a gift being in place, right? Or there's cases where the donee wants to change the use of the gift after years of time. That is simply not the case here. We are not asking to do something different. Largely,
Kolb case consistent with the outcome you seek here? And that was a CPRE case.
I think, consistent here in looking at what are the underlying intents here. The notes, again, go back to he wanted an oncology center, and that is what we have offered to prepare. We would be able to offer chemotherapy, all of the other supporting circumstances right in Floyd County. It's Exhibit 130 that had the full proposal. We've engaged an architect. I mean, we are ready and able to provide these cancer services in the county, but for the regulatory impossibility, which he could not have anticipated.
Record that talks about the inability to have a radiation component to it, how that affects it being a cancer center.
There is testimony in the record by the hospital administrator regarding kind of the CON requirements and how that would limit us from being able to get a CON. They are working and had proposed some transit options to take patients who need radiation, and there were facts in the record that most patients rely on chemotherapy treatments. That did come through in the record as opposed to radiation. So still having the oncologist in the spaces, having doctors there, there are still, it is unquestionable that cancer services can be provided in the absence of radiation therapy, and that has never been questioned by Mayo, that it would not therefore qualify as a cancer center, and the district court correctly found that it would. And I just want to talk briefly, there were some arguments made at the lower court level and again on appeal about the sufficiency of the use of funds. We certainly think the use of funds here are appropriate and that the hospital would have provided a robust cancer center available to the individuals. And if I can just hit one last point here, unless you all have any other questions, I want to talk about, again, Mayo's counsel argued today in their brief on this kind of evidentiary quagmire we end up in here when we're looking. Certainly we would posit, and I think the case law supports, that there is a presumption that the testator does not want the gift to fail. The restatements support that approach, and I think Beaver in the case law does. You know, the comments to the restatement first, which was adopted and followed in Beaver, specifically note that, excuse me, where a circumstance external to the person who is to perform results in impossibility, that fact tends to an inference that non-performance is excused. So it was up to Mayo then to come, the party who intervened and raised these questions, to rebut that presumption and that evidence. We believe they have not had to, and we would ask this court to affirm the district court's ruling and award the residuary funds to Floyd County Medical Center to build a hospital.
More, I'm sorry. You pointed out the sort of absurdity of just having a room that we called the radiation room, right? And that would be a technical fulfillment. But let's take the sort of absurdity issue to the other extreme. I mean, it seems to me that you were focusing in on the cancer in the first sentence, right? Sort of cancer care area, and that you get to determine what pieces and parts go into it. And as long as there was a room that said, this is the cancer care area, oncologists, please have a seat and rest your feet, that'd be good enough. And so I guess my ultimate question is, where the testator has delineated these 5 or 6 specific things, how big of a stickler do we need to be on that?
I understand that, Your Honor, and I think just to be clear, our proposal will have an oncologist on staff. We will have the remainder of those, right, and the remainder of the items here. And certainly, I think building a room to put radiation, I mean, according to Mayo's argument, would comply, but as a critical access hospital, we take very carefully our ability to spend those funds, right? And I think when you're looking, again, it goes back to the impossibility doctrine and ultimately back to the testator's really intent and goal in giving this money. That is what the impossibility doctrine really looks at. If I wrote something and knew that it was impossible, would I still want to give it to you anyways? But we didn't know that he knew that, right? And I think everything around this and all the other evidence here shows that we were his primary charitable target, and he would want us to keep the money.
Comfortable with the, and this is de novo review, right? We get to find the facts anew.
De novo review to review the facts anew, giving weight to the trial court's findings, of course.
comfortable with the trial court's finding that Mr. Stille was unaware radiation was an impossibility, or he probably would have done something different with this, with his will. But for the estate of Beaver to win for you, we have to find that he still would have intended to go forward had he known. And what evidence supports that?
Your Honor, we have to look, it's in the absence of him expressly saying, if they can't do this, I won't, like, right, I need that. We have to look at all of the other extrinsic evidence here, which again is what the trial court looked at and what I kind of reiterated earlier on the large sum goal of his giving to Floyd County Medical Center over the course of his life, his decreasing desire to give to Mayo. I mean, there's evidence in the record that he had a bad experience at Mayo. He may take them out of his will. So we're really looking at where ultimately did he want the money to go. And I believe there is ample circumstantial evidence presented to the court that it was to Floyd County. Thank you.
Maassen?
I want to make 3 principal points in my rebuttal time. The first gets back to this question of whether In re Beaver in fact applies to charitable restricted gifts. And my first point I just want to make is it is very apparent that these lines of cases have developed separately for some reason over centuries, and that never betwixt the two shall meet, at least over many centuries of law development. The second issue I want to address is if you have In re Beaver apply to charitable trusts, In re Beaver, by its terms, applies only to wills. So you could have the situation where charitable trusts created under a will are treated differently from charitable trusts created under an express trust instrument or a gift letter, or some other condition under which the myriad ways a charitable trust can be created, where a gift is given for restricted charitable purposes. I think that's pretty strong evidence that charitable trusts should be treated like other charitable trusts with similar principles.
In this case?
I think the Cole College case that I believe Justice Mansfield authored, restatement of trusts, 3rd, section 28, and then the Eccles against Loudenberry case. Those authorities stand for the proposition that where you give to charity and you put restrictions on it, that is a charitable trust. I don't think that needs to detain the court very long. So I've got qualms about Beaver in general as well. We're not seeking or asking the court to overturn Beaver. That issue is not presented in this case because it is in fact a charitable trust and Beaver doesn't apply. But in 20 years of practicing probate litigation, it's the only doctrine I can think of where we don't ask what the testator in fact intended. We make up what we think the testator would have intended under circumstances where, by definition, for this doctrine to apply, the testator had to have no intent, just didn't anticipate it. That seems like very treacherous ground for any court to get into, and it results in, I think, the thing that was pointed out in the Beaver dissent. This results in judges picking what they want, basically. Or you can have disagreements between, like in the Carpenter case, the majority and the dissent, they pick different purposes that they think the testator was trying to get at. Our jobs, when we're trying to deal with wills, is to get at actual intent, not intent we think that there may have been.
Hypothetically, if Floyd County had raised the C-Prey doctrine in district court, would you have made the same record that you did or a different record?
I think we would have made a different record, Your Honor, but C-Prey would not apply here, both because of the specific charitable intent and then also the gift over to Mayo Clinic, which we discussed before. But that is not going to be before the court now or when we go back down. It's never been requested by FCMC, not in their pleadings and not in their pretrial briefing, and so we didn't try a C-Prey case.
If obviously you want us to reverse the ruling that awards the bequest to Floyd County, but then what happens? Does it go back for litigation, or do you win, or does the district court then have to decide whether the fact that Floyd County remains independent is fatal to the bequest to the Mayo Clinic?
The answer is that the case gets sent back down for the court to determine what happens in light of the failure of FCMC's gift. And the court did not reach that question other than to make the findings on the ambiguity of the will and the testator's specific subjective donative intent. We also presented two doctrines to the court that the court did not rule on: implied gift, where I discussed that briefly before, where applying Porter and its progeny, where you have one condition that a testator thought of, but then didn't consider another. You look for actual intent from the plan or scheme of the will, which is black letter law in Iowa for how you construe a will. Then the third request we did make, both in our pleadings and before the trial court, was to reform a charitable trust here because of a mistake of fact or law, which pretty plainly, the series of events with Attorney Kennedy and how this will came to be what it is. Reformation of a charitable trust is a doctrine that's available. The trial court made no findings on that. Then specifically on the third point that I just wanted to touch on is on Mr. Stille's specific intent, even if you apply Beaver. And there, where he anticipated, I see my time is up. So because of the specific anticipation, and also I just wanted to point out, because of the gift over, which has been argued does not apply because it is not expressly stated in the will. That is, however, still extrinsic evidence of what he would have intended, having anticipated the failure. But even if he didn't anticipate the failure, that gift over, if the cancer center cannot be built, and under Carpenter, and I think it's undisputed, you do consider extrinsic evidence for that last part of the Beaver test. Unless there are any other questions, I thank your honors for your time.
The case is now submitted, and the court will adjourn for the morning.